Repeatedly, the government has argued that they have a right to try their case, to present their evidence. Sure they do. But, you know, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate to every piece of evidence that they want. I have respectfully objected to you with the introduction of this stuff going into the trial. I understand your ruling, and quite frankly, it makes sense. You're trying a case. What I can't fathom is the district attorney's intent to put a circus in front of this jury that's calculated to just inflame the passions.
The circumstances of this horrific act are not in dispute. That single line, delivered by defense attorney Kevin Reddington in a Massachusetts courtroom, was not a confession, it was a strategy. The defendant, Lindsay Clancy, admits she killed her 3 children. The legal question is not who did it. The question is whether the act was murder or a symptom. Think of a snowman standing in a front yard in Duxbury, Massachusetts, slowly melting under the winter sun. It was built just hours before the children died, a frozen snapshot of ordinary life left behind while the house behind it became a crime scene.
Put a circus in front of this jury that's calculated to just inflame the passions of the jury, repeatedly placing in evidence items such as having
But the trial's opening week didn't wait for opening statements to detonate. It exploded during a motions hearing on evidence access when Reddington accused the prosecution of designing a legal strategy calculated not to inform the jury, but to inflame it. He called the state's plan a circus. That word, circus, was a direct attack on the integrity of the Commonwealth's case. It alleged that the sheer volume of painful evidence was not a search for truth, but a weaponized display of grief. The accusation was that the state intended to break the jury emotionally before it could think rationally. The paperwork already knew.
I still want to say that I think it's reprehensible the way the government is trying this case.
Your Honor, if I may, I'd just like to say that I understand why defense counsel would want to brush past what happened to these children, whitewash away what happened, and focus on something else.
Here's what we're going to do. We're going to end that now. All right?
So he gets an opportunity to say it.
The prosecution absorbed the blow and then returned fire with a single devastating structural logic. The assistant district attorney didn't match the emotional temperature of the room. Instead, she pivoted to arithmetic. She broke the state's witness list down into cold, hard multipliers. 3 child victims, 1 adult defendant treated at the scene, 1 father so shattered he was transported to the hospital, 5 separate human beings requiring simultaneous emergency intervention. The massive first responder list, she argued, was not a theater production. It was a mathematical consequence of the defendant's actions.
When it's time for the Commonwealth to respond, things get tense all over again.
Here, unfortunately, we have 3 victims. So that multiplies those witnesses by 3. We also have the defendant herself who was treated at the scene. So then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them, that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5. Now, when the first responders arrived at the home that night, they thought they were responding to 1 victim, the defendant. Then they found out that the children were there, and they found them in the state that they were in, and it was a chaotic scene. They're asking for more help. They're trying to figure out what's going on. They're trying to treat these children, and so there's a lot of handing off. People start CPR. People move on to another child when someone else arrives who's better equipped to deal with, say, a baby versus a 5-year-old. And so we have multiple people working on these children trying to save their lives and then get them to the hospital and get them treated, and unfortunately, none of them survived. But the Commonwealth did not choose the number of victims, the defendant did.
Unfortunately, we have 3 victims, so that multiplies those witnesses by 3. We also have the defendant herself who was treated at the scene, so then that's a 4th multiplier. Then you also have Patrick Clancy, who was so devastated upon finding his children in the manner that he found them that he was in an awful state and had to be brought to the hospital as well. So that's multiplying the people here by 5.
The Commonwealth did not choose the ages of the victims, the defendant did. The Commonwealth did not choose the horrific nature in which they died, the defendant did. It is not the Commonwealth putting on a circus or a parade, it's the Commonwealth presenting the evidence in this case to prove that the defendant killed those children in the manner in which they were killed. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So if he would like to tell me which of these children don't matter.
You know what?
Then came the rhetorical blow that collapsed the entire defense motion into a moral paradox. The Commonwealth did not choose the ages of the victims. The defendant did. The Commonwealth did not choose the horrific nature in which they died. The defendant did. Now, if defense would like us to reduce some of these witnesses, that would mean not talking about one of the children. So, if he would like to tell me which of these children don't matter. It was a verbal trap from which there was no clean exit.
I'll tell you, we don't need that. All right? We don't need that.
Lindsay Clancy herself was so overcome with emotions during these arguments, by the way, that she began crying. The judge made note of this motion, but ultimately decided.
The judge immediately cut off the line of questioning, but the damage was done. The courtroom fell into a heavy silence, and in that silence, the defendant, who is permanently paralyzed from the waist down following a suicide attempt on the day of the killings, lowered her head and wept. 2 nurses, present at all times behind her wheelchair, remained still. The only movement was the quiet shaking of her shoulders.
And this is important, as prosecutors will later argue Lindsay murdered the children with premeditation, making sure that Patrick would be out of the house long enough that she could complete this act without interruption. But according to a lawsuit filed by Lindsay's team, that's not exactly what happened. Yes, she did send Patrick out to get dinner, and yes, she did ask him to run to CVS to pick up something for Cora. But after that, they say she suffered a severe mental breakdown.
Understanding this courtroom collision requires stepping back to January 24, 2023, and a single Google search conducted at 4:00 p.m., Lindsay Clancy looked up the driving distance to a restaurant called 3V in Plymouth. Prosecutors say this search proves she was calculating the time window she needed, the exact number of minutes her husband Patrick would be absent from the house. She then sent him to pick up dinner and run an errand at CVS. The prosecution calls this premeditation. The defense tells a different story entirely about what happened the moment Patrick's car left the driveway.
This is straight from that lawsuit. It reads, as soon as Patrick left to pick up the food, there was a loud, demanding, repetitious voice. This is your last chance. Kill the children so you can kill yourself. Lindsay's team argues she felt a force come over her and started to experience a series of hallucinations. She says she experienced a dreamlike state where she had no choice but to follow the orders of these voices, and then described watching herself carry out the murders. Back to the lawsuit, Lindsay described, I lost all control.
The defense lawsuit describes a voice that arrived the instant she was alone, and we quote directly from that legal filing. As soon as Patrick left to pick up the food, there was a loud, demanding, repetitious voice. This is your last chance. Kill the children so you can kill yourself. Lindsay later described the experience to her legal team as watching her own body act without permission. Her precise words in the filings, I lost all control. My body started acting without any control on my part. I was just following commands, all action. The voice demanded action.
Strangle each of her children, uttering, go to God, baby. Prosecutors say Lindsay used exercise bands to strangle each of her children before ingesting a substantial amount of medications, cutting her wrists and neck, and jumping out of a second-story window to land on the frozen ground. She suffered.
What followed was methodical and devastating. Prosecutors say she strangled 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan with exercise bands, then ingested a massive quantity of medications, cut her wrists and neck, and jumped from a second-story window on a frozen ground. She survived. She is permanently paralyzed from the waist down.
Anxiety and depression, especially after her second and third children. After the birth of the third baby, Callan, Lindsay's defense says her symptoms reached an all-time high. They say she was diagnosed with bipolar disorder and even admitted to a psychiatric hospital just north of Boston for her struggles with thoughts of self-harm. Her stay there happened in the weeks before the murders, but her mental health treatment started way before that. According to court docs, Lindsay had been on a regimen of up to 13 different psychotropic meds, both to monitor her mood and her sleep. That's medications like Prozac, Zoloft, and Ambien. A lawsuit filed by Patrick Clancy would later refer to all of these prescriptions as a cocktail that created the perfect storm of terror. Just this year, Patrick filed a lawsuit against
This is where the two narratives violently diverge. Was she a calculating killer who planned the murders around a takeout order? Or was she a woman drowning in what medical records show was up to 13 different psychotropic medications? A regimen Patrick Clancy's lawsuit against her doctors later labeled a cocktail that created the perfect storm of terror. Her medical history shows a diagnosis of bipolar disorder, a recent psychiatric hospitalization for thoughts of self-harm, and a cascade of prescriptions including Prozac, Zoloft, and Ambien.
Straight from the Commonwealth statute, it reads, if the Commonwealth has proved the elements of the offense beyond a reasonable doubt, the Commonwealth must also prove beyond a reasonable doubt that the defendant was criminally responsible at the time of the alleged offense. Under the law, a person is not guilty if they lacked criminal responsibility when they committed the offense. This is sometimes referred to as not guilty by reason of insanity. There is no burden on the defendant to prove that they lacked criminal responsibility. So that means zero burden on the defense to prove that Lindsay Clancy had a mental disease or defect. In fact, it's all on the burden of the Commonwealth to prove that despite any sort of diagnosis, that Lindsay Clancy was criminally responsible at the time of the murders. The statute goes on to specify, to establish that the defendant had the substantial capacity to conform their conduct to the law's requirements, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed at the time of the alleged offense did not
Massachusetts law imposes a unique burden here. Under the Commonwealth's lack of criminal responsibility statute, colloquially known as the insanity defense, the prosecution carries the entire weight of proof. The statute reads that the state must prove beyond a reasonable doubt that any mental disease or defect that may have existed at the time of the offense did not deprive the defendant of the substantial capacity to conform their conduct to the requirements of the law. Translation: Lindsay Clancy's legal team does not have to prove she was insane. The Commonwealth must prove she was sane.
Of evidence be impounded, meaning they could not be released to the media or the public. The motion reads in part, the potential harmful and everlasting emotional impact to Mr. Clancy and his family of any public dissemination of such graphic and sensational evidence and exhibits related to his 3 children is immeasurable. The items that Patrick is hoping to keep away from the media are the following: the 911 call that Patrick made when he found Lindsay Clancy.
This inverted burden of proof makes the emotional architecture of the trial extraordinarily delicate, and that architecture was directly threatened by a motion filed by Patrick Clancy himself. Now divorced from the defendant and remarried, Patrick sought to impound graphic evidence from public release, the 911 call, autopsy photos, and the clothing the children wore when they died. His motion described the potential harmful and everlasting emotional impact of public dissemination as immeasurable. He was not trying to block the jury from seeing this evidence. He was trying to prevent it from becoming permanent digital fuel for public consumption.
I've been in this court every time we've had pretrial hearing indicating to the court that the circumstances of the death is not in dispute. The circumstances of this horrific act are not in dispute. Repeatedly, the government has argued that they have a right to try their case, to present their evidence. Sure they do. But, you know, even though we're in a court, let's talk a little bit about humanity. Let's talk a little bit about how we should try this case. I have indicated repeatedly that we stipulate.
Kevin Reddington seized on this request to launch his broader attack on the state's trial strategy. He told the judge the defense had repeatedly stipulated to every piece of evidence the prosecution wanted to introduce. The facts of the deaths were not contested. The only contested terrain was the state of Lindsay Clancy's mind. And yet, he argued, the prosecution was insisting on parading 17 separate first responders through the courtroom, one by one, offering them water, offering them time to gather themselves, a slow motion pageant of trauma. The paperwork already knew.
Just, Your Honor, that it serves no purpose other than to inflame or try to inflame the passions of the jury. One right after the other, offering them water, offering them time to gather themselves. And it may have worked in the grand jury, but it shouldn't work in a jury trial.
Reddington's precise words to the judge, I suggest to Your Honor that it serves no purpose other than to inflame or try to inflame the passions of the jury, one right after the other, offering them water, offering them time to gather themselves. It may have worked in the grand jury, but it shouldn't work on a jury trial.
Following. The defense in this case is that Ms. Clancy is not guilty due to not being criminally responsible at the time that she killed her 3 children. This is commonly referred to as an insanity defense. Is there anything about this so-called insanity defense that would offend you or cause you to not be able to fairly decide this case? Additionally, the questionnaire asked a lot about mental health for obvious reasons. A few of these questions included: have you, a family member, or close friend ever been diagnosed with postpartum depression, generalized anxiety disorder, or bipolar disorder? Another question asked: have you, a family member, or close friend had an experience with a psychiatrist, psychologist, or mental health facility?
This pretrial war over emotional strategy was made even more urgent by what happened during jury selection. Potential jurors were dismissed one after another, not for bias, but because they physically could not maintain composure. The jury questionnaire asked bluntly about mental health history, postpartum depression, bipolar disorder, generalized anxiety disorder, and whether any experience with psychiatric care would impair impartiality. Prospective jurors walked into individual voir dire just inches from Lindsay Clancy's wheelchair and broke down crying. One seated juror later returned to the court and openly admitted, "I just don't know if I can handle being on the jury." He was excused.
I even could hear him over the white noise, and this is what he said. It's a direct quote. "I just don't know if I can handle being on the jury. I've just heard about it, and a crime like this is really just horrible. I don't think I can handle it." And mind you, all of this is said just inches from Lindsay Clancy herself. Now, that juror was ultimately removed from the jury, as were 2 others who had previously been seated.
The final seated panel, 12 women and 6 men, now holds the entirety of this impossible calculus in their hands. They must decide whether the Commonwealth has proven, beyond a reasonable doubt, that a woman hearing voices commanding her to kill was nonetheless capable of obeying the law. That legal standard is what makes the opening week's firefight over witnesses more than procedural theater. Each first responder who describes the scene will either be essential context or accumulated emotional weight that tips the scales. The jury will have to distinguish between evidence and amplification.
So you'd be prepared that the defense objection will be it's cumulative? And we come over here, and if there's some reason why there's something else that this witness brings, or a reason why you want to call, then we'll deal with it at that point.
The Commonwealth will be prepared.
All right. So I'm going to take no action on this, assuming that it will be raised again in the next couple of weeks. We'll deal with it as it comes up. I appreciate the parties raised. This is exactly why we have motions in limine, so I know that this is an issue that's coming up. I appreciate the Commonwealth setting out what their response is, so I'm kind of ready for that as well. So I'm not going to take any action.
The judge refused to rule immediately on limiting the witness list, deferring the decision to the trial itself. He told both sides he was now prepared for the objection when it resurfaces. He is essentially holding a pressure valve, waiting to see how much pressure the evidence itself generates. And the very first source of that pressure has been identified. Kevin Reddington confirmed that the state's opening witness will be Patrick Clancy, the father of the 3 dead children, the man who found the bodies, and a key witness who will be questioned under special circumstances that allow the defense to begin presenting its case during cross-examination. This is an unusual legal maneuver, and it means the trial will open not with a procedural frame, but with an immediate human collision between the prosecution's narrative and the defense's counter-narrative, delivered through the same grieving witness.
Dawson and Callan Clancy, their lives were cut far too short. No matter how this all shakes out, it's going to be a monumental case, and we'll be there to cover it all. Law and Crime will be live streaming the entire trial, gavel to gavel, and I'll be here to give you recaps as the most shocking courtroom moments unfold. And that is where today's episode of Scandal leaves us for now. If you like what you saw and you want to see more or connect with me on social media, you can find me on places like Instagram @Sierra Gillespie.
At the center of all this legal machinery lie 3 names that will be invoked thousands of times over the next 6 to 8 weeks: Cora Clancy, Dawson Clancy, Callan Clancy. The question of which of these children don't matter was a rhetorical trap. The answer, of course, is none of them. But the deeper question now moves toward the jury. Can a legal system that demands criminal responsibility be proven beyond a reasonable doubt deliver clarity in a case where the only person who knows what happened inside that house says she was not the one acting? Nobody asked. Nobody answered.
Action on that.
Court is dark on Friday, but opening statements are expected for Monday. And I've been told by Kevin Reddington himself that the first witness is expected to be Patrick Clancy. He'll be called by the Commonwealth as their star witness, but also will be questioned by the defense under special circumstances, meaning it will be more than just cross-exam, but the ability for the defense to put on their case a little bit early.
The trial's opening statements are expected Monday. The public record will begin accumulating testimony immediately. We direct you to the Massachusetts court filings in Commonwealth v. Lindsay Clancy, specifically the defense's motion to limit first responder witnesses and Patrick Clancy's motion to impound evidence, both available through the Plymouth County Superior Court docket. Read them and ask yourself, where is the line between presenting necessary evidence and staging a performance of grief? And who inside that jury box gets to draw it? We'll be watching. Comment below.